Hi, my name's Alex Dolphin, and welcome back to another episode of Ex Ante. Today we're going to discuss the case Printz versus United States. This case was heard in the Supreme Court of the United States in the year 1997. Let's go ahead and jump into the facts of the case. So to understand this case, we need to understand the Brady Act. The Brady Act was an act passed by Congress which enforced background checks on purchasers of handguns. So if you go to the store to buy a handgun, you're going to have a background check done on you before you can buy that handgun. While the federal government was getting its background check system up and running, the Attorney General was overseeing that. The United States government had asked states to conduct the federal government's background check. So the federal government had asked, hey, states, we don't have our background check system up yet, but will you basically do the background checks for us until we get our background check system up? So some chief law enforcement officers from a few states challenged this, and they said, it's not constitutional what you're asking us to do. It runs afoul with the 10th Amendment because you can't force us as state actors, state agents, to implement and enforce a federal statute. We are state agents. We are not federal agents. And for that reason, you can't force us to implement your federal statute. So they challenged the constitutionality of the Brady Act and essentially what the United States was doing with the Brady Act via the 10th Amendment. Now, the majority holds in favor of these CLEOs, these chief law enforcement officers from the few states. And they say that this is a violation of the 10th Amendment. The 10th Amendment, what it is meant to protect is the interests of the states from the federal government. It's basically the Federalism Amendment, and it's meant to protect states from being forced into implementing federal programs or federal procedures. So now this federal procedure of the background check, it could be run by the FBI, it could be run by a federal agency, but you can't run it through the states because then you're forcing the states to exercise their state power on a federal statute, and that is unconstitutional, writes Antonin Scalia. He talks about the importance of federalism, and it's not okay because we basically are dealing with a few sovereignties here. We're dealing with the sovereign of the state, and we're dealing with the sovereign of the federal government. And the framers meant to split those two sovereigns, right? They didn't mean for the states to become local agencies of the federal government. So that is the rule. It's a powerful decision in regards to federalism, and it just reinforces the importance of the 10th Amendment, the power of the 10th Amendment in prohibiting the federal government from requiring states to enact federal programs or requiring states to enforce federal statutes. So Justice Stevens writes a dissent. Basically, he says that the interest in handgun background checks outweighs the interest of federalism. That is the overarching theme of his argument. And one of the first and main points that he makes is Congress is acting within its enumerated powers. The Commerce Clause gives Congress the authority to regulate interstate commerce. And now handguns being sold to customers, that is certainly commerce. And so Congress can reach that purchase of a handgun and it can regulate it via the Commerce Clause. Now, because Congress is acting within its enumerated power in the Commerce Clause, it can force the states to do things, to implement its enumerated powers. So you see a key fork in the road between Justice Scalia and Justice Stevens here, where Justice Stevens says, well, you know what, Congress and federal government, we really can force the states to do some things. We can't force them to do everything, but we can force them to act within the federal government's enumerated powers. Now, regardless, the majority of the court rejected that argument, but it was a strong one. To illustrate what Justice Stevens was thinking about, we could think of an emergency scenario, and he writes about this. We could think of a scenario where our country is being attacked. Let's say our country is being attacked by Cuba, and Cuba is attacking Florida. Now, Florida by itself as a state doesn't have the ability to wage a war and win against Cuba, let's say. The Florida National Guard isn't strong enough to defeat the Cuban National Army. Well, what that's going to take is some cooperation amongst the states in defending the United States. And he says in these emergency war scenarios, we're going to need the federal government to command maybe the National Guard of Alabama, maybe the National Guard of New Orleans, maybe the National Guard of Georgia. And we're going to need the federal government to command those other states to act in conjunct and to act in concert with one another to combat federal emergencies. We could think of coronavirus, where maybe we need states to act in concert with one another to prevent coronavirus. Maybe we need states to basically corroborate their numbers and try and prevent the spread of coronavirus from boundary to boundary. And so maybe we, in emergency scenarios, we do need the federal government to be able to force the states to act on the federal government's accord. And this is just a key argument that goes back to an argument that existed at the formation of the Constitution. And how much power should the federal government have, and how much power should the states have? And this case shows that that argument is still alive and well. So thanks so much for watching. I hope you enjoyed this video. If you'd like to see more, go ahead and hit that subscribe button. And I hope you have a nice rest of your day. Bye-bye.